Hi, I'm attorney Niraj Singh. In the following video, I'm going to go over a hypothetical DUI arrest and then identify some possible weaknesses and defenses. Now, the facts might not be exactly the same as your case, but hopefully it'll still be able to shed some light on your situation nonetheless. Let me start off by saying that DUIs are, in my opinion, a very interesting area of the law. Unlike many other areas of criminal law, the stigma of a DUI arrest is very different than that of a, let's say, burglary or battery charge. Anybody, and I mean anybody, can get a DUI, regardless of their background, education, or social class. All it takes is one drink too many and the poor decision to get behind the wheel. For example, I've represented nurses, doctors, other lawyers, corporate executives, you name it, in their DUI cases. While it would be very unusual to see a heart specialist charged with burglary, the same can't be said about a DUI. With that said, a DUI is a very serious charge and not to be taken lightly. Not only can it be very dangerous for other drivers on the road, but you risk death or serious injury to yourself and your passengers. Also, if you're an immigrant without a green card, a DUI can result in your deportation and or denial of naturalization. Finally, we're living in Southern California. Losing your driver's license is almost like losing your freedom. For many people, it could actually mean losing their job. It's a very serious situation. So without any further ado, let's dive into our hypothetical DUI case. Don Driver was driving home at midnight on the 405 South when he gets pulled over by the California Highway Patrol. When the officer approaches Don's window, he starts asking him about his night. Where is he headed? Where is he coming from? How long has he been there for? And then finally, he asks whether Don has had anything to drink tonight. Don admits to having one or two drinks earlier in the night. When Don asks why he was pulled over, the officer tells him he was swerving and his wheels crossed the lane divider. The officer asks Don to step outside of the vehicle and submit to a preliminary alcohol screening test, which Don refuses to take. The officer then has Don perform a number of field sobriety tests, also known as FSTs. According to the officer, Don failed every single one of the FSTs. At this point, it's about 30 minutes after the initial stop, and the officer asks Don whether he would like to submit to a breath or blood chemical test to determine his BAC. Don opts for the blood test and is then placed in the patrol vehicle and driven quickly to the nearest hospital or back to the police station for the blood draw. Don is held overnight and released in the morning when he is sobered up. He is given two pieces of paper, a yellow citation with the court information and a pink sheet with DMV information. Now, let's dissect this hypothetical by walking through it fact by fact. When the officer approaches Don's window, he starts asking him about his night. It's important to note that an experienced officer will have possibly hundreds of hours of DUI investigation training under his belt. Very rarely will they ask you a question that doesn't serve a purpose towards their investigation. And often, you might not even realize that they're even conducting an investigation. So here, the officer's questions were twofold. Sure, he wanted to know the answers to his questions, but also he wanted to get Don talking so that he could smell Don's breath, pay close attention to Don's speech to see if he was slurring, and to observe Don's eyes to see if they were bloodshot and watery. The officer tells Don he was swerving and crossed the broken lines. Now, in order for the police to pull Don over to begin with, they need what's called probable cause. Probable cause means that the officer, through personal observation or reliable intel, had a reasonable belief that you broke the law. Without probable cause, a case must be dismissed, even if that means, for example, after making the traffic stop, the officer discovered that Don had other independent reasons for being arrested, such as having illegal drugs in his car. Now, here in Don's situation, the officer is telling him that the reason he pulled him over is because he observed Don swerving to the point where his wheels crossed the lane divider, which is a violation of the California Vehicle Code. But how do we know for sure that the officer did, in fact, observe this or that it even happened? That's where MVARS come into play. MVARS stands for Mobile Video Audio Recording System and is commonly referred to as a dash cam. Nowadays, most police vehicles are equipped with dash cams, and sometimes even the officer himself will be equipped with a camera on the lapel of his shirt. I would issue a subpoena to the arresting agency in order to obtain any and all footage of the officer's observations, starting from when the officer formed his probable cause. In other words, we would see exactly what the officer saw. If in that video we don't see any violation giving rise to probable cause, I would then file a 1538.5 motion to suppress evidence and get the case dismissed. Next, the officer asked Don to submit to a preliminary alcohol screening test, commonly referred to as a PAS, which Don refused to take. Believe it or not, that's perfectly alright. Unlike the official breath or blood test, the PAS is actually not required unless you are under the age of 21 or on probation for a prior conviction. The officer then had Don perform a series of field sobriety tests, and according to the officer, Don failed every single one of them. Now, it's important to remember that FSTs, field sobriety tests, are by their very nature objective. But are officers always objective? Of course not. If the officer is hell-bent on arresting you for a DUI, what's going to stop him from saying you couldn't walk in a straight line or follow his pen with your eyes? This is just another reason why having access to the dash cam or lapel video is important. With that said, FSTs on their own are rarely going to be enough to get a conviction for the prosecution. An accurate determination needs to rely on the experience and training of the officer administering the test. But what if the officer is a rookie cop with less than 10 DUI investigations under his belt? You can see where I'm going with this. Now, let's talk about the more convincing evidence, the breath or blood chemical test. In the state of California, we have what is called implied consent. When you register for your driver's license, you agreed that if and when you were pulled over by an officer, and that officer asks you to submit to a breath or blood chemical test to determine whether you have any alcohol in your system, you must comply, or else you will automatically suffer a 1-year license suspension, among other serious penalties. Next, Don submitted to a blood test and was found to have had a BAC of 0.07 and 0.08. In case you didn't already know, the legal limit in California is 0.08%. However, contrary to popular belief, you don't necessarily need to hit a 0.08% in order to get a DUI. In California, we have two main DUI laws: Vehicle Code Section 23152A and Vehicle Code Section 23152B. Vehicle Code Section 23152A states it is unlawful for a person who is under the influence of any alcohol beverage to drive a vehicle. Note that there is no mention of BAC or any other means of alcohol measurement. This means that in certain situations, you can be charged with DUI regardless of your blood alcohol content. In fact, when you refuse to take the breath or blood test, as we discussed in the previous slide, this is the statute you would be charged with violating, since they may not actually know what your BAC was. Another way you might be charged under this statute is if you were involved in a traffic collision and were found to have had a BAC of less than 0.08%. You may not have been over the limit, but by virtue of the accident, it can be argued that you were feeling the effects of alcohol. Vehicle Code Section 23152B states it is unlawful for a person who has 0.08% or more by weight of alcohol in his or her blood to drive a vehicle. Now, one of Don's readings was 0.08%. So what would I do for Don in this situation? Since Don chose the blood test, I would order a blood split to verify that amount. When Don gave a sample of blood, only a portion of it was used to determine his BAC, meaning there is still more of the sample remaining. I would ask the court for permission to obtain a sample of that sample and have it tested by an independent lab, not the police department's labs. If you may recall, in 2013, an error by the Orange County Crime Lab was revealed, resulting in about 200 people's BACs being lower than originally reported. Finally, if after reviewing the MVARs, there is legitimate probable cause, and if after legitimate blood or breath test results, Don was found to be over the legal limit, I would then shift my focus from dismissal of Don's case to mitigation, meaning I would then enter into negotiations with the prosecutor for a lesser charge. There are three main non-DUI charges that I would try and obtain for Don. First, what's commonly referred to as a wet reckless. Second, a dry reckless, and third, exhibition of speed. All three of these charges have their own pros and cons, such as less driving suspension, fines, and probationary periods. To find out more about these lesser offenses, please feel free to explore our legal blog. If you or a loved one has been charged with driving under the influence, it's very important that you contact us within 10 days from the arrest to avoid an automatic license suspension. We understand that being arrested can be flat out scary, but going through the court system alone or with an inexperienced attorney can be even scarier and can result in long-term effects on your personal life and career. Call us now for a free consultation.